they are receiving the C100 and they complete the C7. Oh, our daughter came back and said you slapped her. Required by law for you to be involved. Some people call that kidnapping, right? Hello, everybody. I'm Kevin. This is the Power and Control Wheel. I might change the name at some point, but right now I'm focusing on the Power and Control Wheel because weaponizing your children is on there, which is parental alienation, which is what the courts are pushing back on, which is pretty much what causes us problems when we try to get access to our children after we have separated or been separated. So I would like to talk about navigating child arrangements court in the UK. So are you being denied contact with your child after separation? But do you have parental responsibility but feel powerless? I know people who don't actually have parental responsibility and still say that they feel powerless, but yet they actually do have some kind of contact. What is going wrong? Let's walk through the process together. Now, this is not my area of expertise. I'll put you over to Sarah Squires. Go have a look at her. That's her area of expertise. Sarah, if you're listening, there you go. Thank you for everything that you've done for me as well. Appreciate that. Okay, let's start with you've left, or the other person's left, and you had no idea that it would be so difficult to be able to access your child. It's your child, right? So why don't we have access to our child? Okay, we are being denied contact with our child after separation. And it can be done because the law states that we do not have a right as separated parents to spend time with our children. That's not me saying it. That is the Gov UK Parental Rights and Responsibilities. The second part says that in black and white. Although there is an understanding from Parliament that both parents should be involved. I'm not sure in being involved in bringing up the parents, but should be involved in some way. So what happens if the access is denied to your children when you're a separated parent? Okay, let's take a first example, shall we? We'll have a look at several examples. All right, so parent on the birth certificate with no safeguarding issues is refused contact without reason. Okay, so the informal agreement is broken repeatedly and messages are ignored. Now, you'll understand this yourself, I'm sure. You would have no idea that when you were to break up, that all these informal agreements were flexible to the point of mind bending. That you thought that there was an agreement between the two of you, and you put a lot of years into believing this person who is now keeping the child away from you, who is now obstructing, who is now making excuses, making reasons, or done right, just saying to you, so what are you going to do to bring up your child, our child? What are you going to do to have involvement in your child's life? But yeah, I know we agreed that we're going to be on this date, but there's a concert and they want to go and they want me to take them, or their friends are coming over. You don't want to do that to them, do you? They're really looking forward to that. We'll talk about it another time. That other time doesn't come along. Here's another example. You've given your word all the time, but you're now being given inconsistent contact. That's what this one comes to. 1 week, you might be allowed a few hours, and then nothing for weeks. All you want is some kind of consistency, not just for you, although you're trying to reestablish your life, so you need some kind of consistency, but you also need some kind of consistency with your child, because your child thrives on consistency, and their refused contact, or your refused contact. So a few hours and then nothing for weeks. The other parent changes plans last minute and undermines your relationship with your child. So the problem you've got basically is because it says in the UK Gov law of parental rights and responsibilities it's not legally enforceable without a formal child arrangements order. That's going to cost you money. Okay. So the only route you have left is through the family courts. Get your dice out. Let's start considering rolling, playing Yahtzee or something. So the other parent, basically, there's you and the other parent and the child, the children. You were parenting, you had a loving relationship, you were fully involved. The I don't know, the relationship was a bit tenuous, or you had no idea that the other parent would behave badly like this. The child is wanting a relationship with you, and now time's going past, and then you're seeing that there's difficulties coming up. The only way that you can resolve this that you thought would be to communicate with the other parent, but the other parent does not want to communicate. It is all about power and control, so it seems. So, like I said, you're now faced with the only other choice. Oh my goodness, I'm going to have to take them to court. They might have told you that. They might have said, take me to court, and you're stuck because you can't even afford to go to court. Or, and even if you can, what's your child going to think? And I guarantee you, maybe this is not going to go well. We'll talk about this in a second. Okay. So, what's your first step? Right. Your first step is your MIAM and your Form C100. You've heard that kicking around loads. Oh, got to get the C100, got to fill this in. The MIAM basically is the Mediation Information Assessment Meeting. You've got to have one of those. It's a legal requirement before applying to court, unless there are some exemptions that might apply. So the purpose of the MIAM is to try to resolve disputes before legal proceedings. Can you imagine? Of course you can. Resolving disputes in mediation with somebody who is being obstructive. I'm not even going to use the word narcissist, okay? Just somebody who is not working together with you. So if there's domestic abuse, you know, that it can be skipped. You can skip right past the MIAM meeting. If there's a sense of urgency or a definite urgent need, whatever, and maybe there's some safety concerns that exist as well, then you can skip the MIAM. That's the mediation. So what is the Form C100? Okay. So the Form C100 that you can download and you can type online, I believe as well, maybe, is a child arrangement order. It's also a prohibited steps order, if I can get my words out. And it's also for specific issues, a specific issue order. So we'll have a little look at these for a second. Okay. Common example. Right. Parent applies for contact after being refused access repeatedly. This is why you're here, because you're being refused access repeatedly. You have to fill in a C100 to do anything. It's got to go to court. Okay. So take another parent, perhaps applies to prevent relocation abroad. Some people call that kidnapping, right? That's a specific issue. So specific issue order. Or to stop a child's name from being changed. That is a prohibited steps order. Because remember, if they are going to change the child's name or take the child out of the country, these are big life changes. These are big decisions, and they are required by law. The UK Gov says this, required by law for you to be involved. They have to involve you, but it doesn't always go that way. So now you're faced with, you've got to go to court. Life's just ticking on, and you just want to be a parent to your child. Now, I'm telling you, your child's going to be affected by all of this, but you already know this. Okay, so the prohibited steps order. Okay, what is that? Right, what does it do? It prevents a parent basically from taking specific actions without the court's consent. I'll go there just for a second. If it's somebody with narcissistic personality disorder, somebody who is on the cluster B somewhere, they're just going to do what they want to do anyways. You know that. You have seen this anyway. Or maybe not. Maybe they're just going to be plain darn difficult as they do that as well. So, like I said before, the prohibited steps order might be to prevent the parent from taking the child out of the country, not just for a visit, not for a week or so's holiday, but if they are taking them out of the country for extended periods of time, perhaps, which may lead to them going forever, permanently. So, second example, preventing the parent from changing the child's school, even without agreement. It does say that they're not allowed to do that. The school has to actually tell you if they are planning to remove the child from the registration, but the school does not have to tell you if the other parent is taking the child away from the school. So it's quite often you don't find out until the child's already been removed. So this is a serious problem. And our courts aren't set up for this. It drives me bonkers just at the thought of it. So, right, specific issue order used maybe perhaps to settle a specific dispute about a child's upbringing. I say maybe because it might be there, but it won't be enforced. That's what happens. You know this. If it's a little game, you know the game that they're playing. An example, deciding again which school the child should attend. Okay, right. So the child's now going to attend 50 miles down the road. Now you can't pick up your child back and forward. Just makes things difficult. It might not even be 50 miles down the road. Road. So disagreeing on religious upbringings, perhaps, even the vaccinations. I'm not saying any specific types of vaccinations, so just the vaccines, basically, whatever it might be. Now, you can also throw Gillett competence in there too. So if the child says, oh, Gillett competent, and the folks say, okay, parent, you're not allowed to be involved anymore. Gillett competence, just to let you know, is the decision that the child has made. The child understands the consequences. The child knows what the child's saying, basically, and knows what it's all about. I tend to differ on that kind of thought process. That's what we've got our parents right here, isn't it? The child does not have the life experience at all to make certain decisions that people say that they are Gillett competent to make. So that gets in the way, and you might then want to go to court and fill in maybe a specific issue order. So the religious upbringings as well. So if they want to not have the child be brought up, let's say, as a Christian, maybe, or whatever other religion, and you had been bringing that child up and you have firm beliefs, well, you can fill in a specific issue order as well. All of this costs you money, unless, of course, you can get some kind of financial help. They stopped that a long time ago, 2012, I think they stopped that. So in amongst all of this, you've got the Form C7, and the Form C7 is the response to the C100. You are filling in the C100, and the other person is filling in the Form C7. So basically, you've filled in the C100, the other person has received it, and they are the respondent. They are receiving the C100, and they complete the C7. So when's it used? Well, it's used to formally respond to the application for the child arrangements. They don't just receive the C100 and that's it. They have the opportunity of filling in some kind of response, and that is on the C7. So as an example, you've got a parent who responds by denying allegations of whatever allegations. You might have put some things in there in the C100, and the other person is saying, oh, I'm not having that. Can I, I didn't do that in the C7, write that down. So they're proposing maybe a different contact schedule, perhaps, maybe. So you're saying, oh, the C100 child arrangement order, I want to be able to see my child 50% of the time, and maybe on the Mondays, Tuesdays, and every other weekend, perhaps, sometimes during the holiday. And the parent who has the child is saying, no, I'm not happy with that. I'm going to fill in the C7. As another example, so the respondent who's filling in the C7, you sent the C100 to them, they raise concerns about your behavior. You know where that is, false allegations, right? So perhaps, or maybe they weren't false allegations. Maybe you did raise your voice. Maybe it's out of context that they're saying, but they're sure as heck are going to wrap it up to make it look pretty juicy, right? So you might have been late at some times. You might have accidentally, not accidentally, you might not have been able to get back to your child once. Some one incident may have happened, which you could have, if you could have changed it, you would have done. But these little things they'll use against you, the tiniest little things, they don't have to be false allegations. So the respondents raised those concerns about your behaviors, maybe suggesting supervised contact. So now instead of having contact with your child as a parent around at your house, if you have a place to live, maybe the respondent is saying, oh, but you don't really earn very much money. Or maybe the respondent is, because you're having to pay child maintenance. So maybe the respondent is saying, well, you've got nowhere to live. You've only got one bedroom. And so the child's going to have to sleep in the bed with you, or he's going to have to sleep on the settee or wherever it may be, even though the child would have your bed and you'd sleep on the settee during those times. Or maybe you're sofa surfing yourself as well. And so the other person, in all their glory and their moral stance, because they know better, am I being facetious? They say that supervised contact, get you in the contact center. And the contact center is actually going to cost you money as well, a lot. So while we're talking about this, let's have a look very quickly at a form called the C1A. This is allegations of harm and abuse. Right. Who fills in the form C1A? Well, either of you do. If you've left, or if they've left, and let's say if you're concerned about your child, if there's harm to your child and you know your child is in danger, there might be a new person, a new guy, a new girl, whatever it might be, any reasons whatsoever. And you can see that there's a danger to your child and you can't even protect your child. So what do? You're going out of your head. You fill in a Form C1A, allegations of harm and abuse. So if there are allegations of domestic abuse or child abuse imposed on you, or if you're the one that is telling on the other parents to say that there's domestic abuse going on, or maybe that was between you and the parent, there was the other parent, domestic abuse going on, or maybe you can see that the new guy, the new girl, and the mother, the father is not getting on, and there's some pretty not good stuff happening right there. So, parent A, let's say one parent, as one example, would claim emotional abuse, maybe coercive control by the other parent. You might want to look up the Serious Crimes Act of 2015. It doesn't all apply, and there are other types of abuse, the most covert, insidious forms of abuse. I would suggest that you don't use the term abuse, you don't use the term domestic abuse, coercive control, or narcissist, or anything like that at all, unless of course there are some diagnoses and it's been through the court and that's actually, you've got the official paperwork on that. I would stick to the behaviors and the incidents, the things that are happening, and let the other people on the other side of that paperwork processing it, let them identify, this is a bit abusive, this is okay. So maybe a parent will report neglect, perhaps, maybe some concerns over the child's emotional safety, because that's a thing, isn't it? Maybe while they're visiting you, perhaps maybe you do have some access, but your child's kind of not acting right. Or you might see cuts on their arm. You might look down and taking them for a ride, and maybe the blazer rides up and you see cuts. Or you might see them starting to smoke dope, or you might see them starting to smoke cigarettes, or they might start using bad language towards you, or they might just, whatever it may be, you might start getting reports from the school saying that their behavior has just gone completely wild when it wasn't like them. It was out of character. So these are kind of red flags that says there's something wrong. What do you do about it? You've got to fill in that C1A form, allegations of harm and abuse. I know that people want to go easy on the other person, and I know that filling in these forms is going to make things more difficult. I know that, but if you don't do that, then nothing's going to change anyway. You're in this situation, you've got that bear's trap around your foot, you've got that rock on your arm, and you're up there in the Andes. Unfortunately, the damage has been done. You have to do something about it. And that rock's not friendly. That bear trap is not friendly. It's your enemy. And so's all the circumstances happening. Unfortunately, and I'm very, very sorry that you're in this situation. This is what you have to do. You cannot go easy on that other person. They're not your friend, and they certainly are not going to go easy on you, because while you're going easy on them, they'll just see that you're weak. And I know you're not, and you know you're not. You're just playing fair, and you're trying not to stir up the bee's nest. Unfortunately, you have to stir up the bee's nest. Okay. So, a couple of key points right here. So, even false allegations as well is the Form C1A. So, it doesn't have to be anything that's happened. If there are false allegations, in fact, they might, I hope you don't, but they might fill in a Form C1A and make false allegations against you. So, you might have a C1A plonked on your doorstep, or somebody's bringing it up saying, this Form C1A says that you've done this. Well, they are false allegations, but these false allegations can delay proceedings and result in reduced or suspended contact as well when nothing's been done, because the respondent, the C7 person who's filled this stuff in, well, they filled in a Form C1A and they've made false allegations. This is one way in which they do it. So the process goes wrong. Okay, let's have a look at some other examples of how the process can go wrong for you, because these are the kind of things that make us think twice about going to court. But remember, the only way that you're going to get access to parent your child is through court. That, unfortunately, is the way the systems work. It's set up. So the MIAM, okay, it takes longer than expected due to the mediator possibly not being available. That does happen. We've had incidences 4 or 5 years ago where we had the big C word come into effect, and that stopped everything. So there's all those kind of things going on. Court hearings even might be rescheduled multiple times, and that would drag the process over a year, 2 years. This goes on for a long time, and you know what's happening with the other parent and your child or your children. You know what's happening, and this makes you go out of your head. So while this process is going on, it's absolutely essential that you remain grounded and you try as best as you can to understand what's going on inside your body so that you can not navigate it so much, but you can manage. You can do damage limitation, not just outside there, but within your own body and your own world as well, and take your time. Let's say, for example, maybe there's a non-molestation order and an NMO. So maybe that's been taken out on you and there's no evidence. And you're like, what the WT friggin' F? Man, man. And you're seeing the other side. You're seeing the true side of this character. That's what a character is coming out right now. So the non-molestation order has been taken out. There's no evidence. You're saying to the police as well, where's the evidence? They say, well, we got to follow it up. And then they're starting to look at you, and then there's other gang stalking going on and all kinds of things. And what's going to happen here is it's going to trigger the social services. Now, we all know about the social services. Okay, so I'm not going to say anything about the social services at all, but they're involved. Even maybe when the police don't have any concerns, the police might say, you know what? We can't actually see anything. There's no evidence. We can't do anything about this. But the social services come in and it all goes haywire from them. Okay, so basically, a non molestation order, by the way, is a civil order which is intended to protect from harm. It's often used alongside or maybe before the family court hearings. It's one of the tools that the little buggers use. I'm trying hard not to say the word narcissist, okay? You know where I'm at on this one. The confrontational people, the people who do obstructing your parenting, the relationship between you and your child, and you can see things going bad and you're going out of your heads. So let's talk real quick about CAFCASS. Because when you fill in the C100, CAFCASS is going to get involved. All right. They're the ones that get involved. Social services get involved when they hear that there is a safeguarding problem potential. So what CAFCASS does is it's a children family um, courts advisory service and support, or something like that. Children family court advisory support service, something like that. And I'm not reading that; it's just trying to remember it. So right, they get involved, like I said, once a C100 is submitted. This is the thing. It's like, you've seen your solicitor. Solicitor said you've got to fill in the C100 because the UK Gov law says you don't have a right to spend time with your child. You have to apply for that. You don't even have a right then. You have to apply to be able to get access to your child. So what happens then is CAFCASS comes in and they conduct a safeguarding call and they compile a report. It's called a Schedule 2 letter. So as an example, maybe a parent is maybe misquoted, perhaps, right? Factual errors, maybe in CAFCASS notes, maybe they're not corrected in time, perhaps. So you've got some concerns right there as well. Not just CAFCASS having concerns, but you now having concerns about CAFCASS. Maybe CAFCASS has recommended no contact, perhaps, based on allegations, false allegations, without verifying the facts. And you're going nuts. The worst thing that you can do at this point is to lose your temper. Some people take out their phones and they record, but you have got to tell them that you are recording. And you've got to check the law to see if you're allowed to as well. What about the first hearing dispute, the resolution appointments? That's called the FHDRA. So the purpose of that is to basically to discuss the case. So basically, you've got the CAFCASS, the review, the notes, and their recommendations. And so this court hearing basically is they look at the CAFCASS notes and they review them, and then CAFCASS makes recommendations. And so this hearing is looking at those recommendations as well, and then deciding on the next steps. So what can happen in when you get to this hearing? Right. So you could have some interim contacts, some intermittent interim in the meantime kind of contact granted to you, or it could be withheld. But you've done nothing wrong. And there's your child. And a lot of time is going past. This is the UK system. I think it's a system in the USA. It's very similar as well. So the safeguarding concerns might prompt a Section 7 report. We'll have a look at that in just a second. A fact-finding hearing, basically, okay? So as an example, maybe CAFCASS doesn't attend, and maybe the magistrate, if you have a magistrate and you've not yet asked for a lawyer, so the magistrate might rely solely on the initial report, and maybe CAFCASS isn't there, perhaps. And maybe there are some misquotes or alterations in the CAFCASS report, but the magistrate is actually is saying, well, it's written down here, so I'm going with it, basically. So this is when maybe the magistrate will say, hang on a second, we're going to need a Section 7 report. This doesn't sound good on these reports. So maybe interim contact is denied pending investigation because somebody has filled in a form and said, look, there's that person's not been very, very safe for whatever reason, maybe any kind of reason. And so in order to make sure that the child is safe, bear in mind, this is taking a long time and it's taking money, then everything has to stop. And basically CAFCASS has to conduct a Section 7 investigation, a fact-finding hearing, basically, and dig deeper into it. All right. So, and more investigations. So I just mentioned the Section 7 report and the fact-finding hearings. Basically, the Section 7 report is ordered if the courts need more detailed information. If they're not quite happy with the situation, maybe even if there's not really anything devastatingly being said, but they're just not happy. Sometimes even CAFCASS can say, Judge, Magistrate, we recommend that the other parent sees the child. Well, based on what the respondent parent has said, the judge might say, or the magistrate might say, well, hang on just 2 seconds. We need to look. I don't feel comfortable with this. I want to look into it just a little bit more. So, what needs to happen there? CAFCASS investigates the child's welfare, the feelings, relationships, and so on. They'll sit down with the child. This is where CAFCASS said the voice of the child. This is where we're saying, well, if the child is in the grips of what you'd want to call an alienator, if the child is being weaponized against you, in whatever way, and even the Family Justice Council says that that's rarely possible, it's totally possible, and we've seen it, we know it. So, to get one child to be influenced, and I can tell you right here, I've had 3 stepdads and a real dad, and the ones who I turned against were the good dads, the good stepdad and the dad, and they'd done nothing wrong to me, and I can tell you that right now. I did not say anything bad about the 2 stepdads who were not particularly nice to me at all. So, and even if I was afraid of those 2, at some point or other, I did not say anything bad about them, or I didn't even notice, I didn't even know. So maybe the child is expressing fear due to that parental influence. This is the respondent's influence. So hopefully, then CAFCASS will say, hang on a second, there might be some parental obstruction going on right here. Let's investigate this a little bit more. Or the court, the magistrate will say, this sounds a bit sus, might be a bit of alienation because there's some that actually do get it. Let's go look into this just a little bit more. So maybe the child wants contact as well. Well, that's confusing because why aren't you able to get contact? And the child's saying, I love you, mom. I love you, dad. I want to be with my mom. I want to be with my dad. They want to be with you. So what can happen is that other parent, the respondent parent, the one who's obstructing, alienating, whatever it may be, is undermining the child's wishes, is not letting that child come and see you, and is saying, no, your parents are danger. No, we for whatever they're saying, they're not letting the child come and see you. So there'd be a fact-finding hearing, and the fact-finding hearing basically is used when allegations of harm need resolving before a final decision. A lot of time has gone. So from all that lot, then you get the Form C79. There's a lot of forms. I hope you like filling in forms. The C79 basically is the enforcement of the court order. So what I've just said basically is you've gone through all these fact findings and hearings, and the court has ordered maybe to say that you do have access and you can have the child spend the time. You know exactly where I'm going on this one. So basically, that one parent is not complying with the court order. And then does the court do anything about it? Well, so that parent doesn't comply with the existing child arrangement order that's now gone through. So your job now is to fill in the Form C79. Again, that's the enforcement of the court orders. So who is it that's completing this? The parent who is seeking enforcement, you. Or maybe the other parent, because maybe you've decided that you're not going to adhere to the court orders, or maybe you do. And maybe the other parent is saying that you don't, and they're going to fill in the C79. What can happen then? All kinds of things, can't it? So, a couple of examples, maybe parent refuses to return the child after the weekend visits. You have to be very, very careful to record everything and to make sure that everything is written down. You cannot underestimate what this other parent will do to try to dismantle and sabotage your ability to parent the child and have the relationship. And they will try in every way they can to sabotage that child arrangement order, the court order. And they'll come back at you, and they've got the tools, the forms to do that, the C79. And you also have that too. Don't be fair. Don't play fair. You sadly have to play, in a sense, almost the way that they're playing. Okay. I always say Churchill wasn't fair to Hitler because he knew that Hitler wasn't that way. The only reason I go back there because I love that whole scenario. It's very much like what we're dealing with the alienating, with the weaponizing the children, with all of this family disruption and the obstruction. Okay. Another example possibly might be repeated canceling, possibly of any kind of contact. Maybe that you're needing contact, and they said, "Oh, I can't this time on this Thursday," but it's your Thursday, and that's in violation to the child arrangement order, the agreed upon times. So you would have to fill in the C79. Other kind of forms that you might come up with would be a form called the EXX160. Basically is applying for help with court fees because the court fees are really expensive, you know that. And this is like people spend thousands of pounds on this just to try to parent their child. That's all they're trying to do. They're not trying to take the other person to court just to try to continue the abuse on the child. And then when they've gained, can you see how it is a bit nonsensical to fight for your child, to get access for your child just for the win? It's so much of a headache. Maybe some people do that. I don't know. But you know what? If they're only fighting for 50% of the time, then, who can complain with that? I'm sure. But then the other party will say, this is what I was saying earlier on. The other party will say, oh, now that person's got 50% of the time. Now they don't want to spend time with that child. This is the kind of things that the women's groups say. I don't like bringing that up right now. Sorry about that. But this is all part of what you're dealing with. Anyway, let's move on because you've got the form EX160 to help with these to finance the court fees, basically. Then you've got the form C2, and that's used to request permission to make a new application, just in case. Okay, because maybe it went wrong, maybe you need to do it again, maybe things have changed. Then, of course, there's not of course, but there's the Form C8 to keep addresses confidential from the other party. So some questions that I've been asked is, do I have a right to know where the other child lives? Well, if they filled in a Form C8 and that's been approved, then no. If the other party can't show that Form C8, then you can argue that yes, you do have a right to know where your child is, where the address is. However, there might have been a non-molestation order placed on you as well. So, although you may know the address, you're not going to go anywhere near that because they're going to call the police. All of this is going to be used against you. Things change quickly when they need it to change, but for you to get things to change takes an awfully long time, doesn't it? Sure does. So the Form D11 for urgent or interim applications before the main hearing. Let's say you're waiting for the main hearing, something's happened. Or maybe you're waiting for the main hearing and the respondent, person over there, the other parent, is just trying to cause trouble. They'll fill in Form D11 and say, oh my goodness, something's happened. Oh my goodness, you've dropped the baby on the head several times or whatever. You're a danger. Really need to. So they'll get in there maybe. Okay. Or it can happen whenever. But the Form D11 is basically for urgent or interim applications to sort things out, basically. Right? So The whole system, as you can see, is quite complex. It's not straightforward, and all of this time goes by, and you are doing your nuts. And the child, you can imagine if you're doing your nuts and you're quite capable of handling general things in life. Obviously, you've not been taught how to handle this. Can you imagine the pain and despair and the things that are going on in the child's body, the somatic kind of things that's happening? It is a train wreck, an absolute train wreck for that child. And although they'll try to present, if they can, as everything's fine, they have to do something. And quite often it is they're trying to keep you away because they can't handle what's going on. So the safest bet is to say, I don't want to be with you. So what are you going to do now? Are you going to still fight? Later on, they're going to say, you didn't fight for me. How much are you going to push? Some of the key takeaways, anyway, for you. So document everything. I said that and I mean it before. Missed visits, slightest little visits, things that maybe just half an hour. You know, the things that may seem irrelevant, because everything that you document, when you look back at it, forms a picture. Any kind of false accusations, even if it hasn't included the police, even if when you've gone round there and they might have said, stop raising your voice, and you know that you've not raised your voice, or you might say something and they'll say, that was aggressive. It might be that they're recording you. It might be they've said it in earshot of your children or somebody else. You have to record this stuff and you have to take it seriously. Any kind of messages, written messages, whatever, messages that you've sent, messages that they've sent, messages that the children or anybody sent. This is a full-time job. It's a sad reality of it. Okay. Delays. Here's something else. Okay. The process is going to take a long time. It is a slow process. So do expect delays. We're not talking about the M25 or the M6 on rush hour. It's a lot longer than that. Even when you're doing everything right, there are going to be delays. How do you handle that? Just make sure that you are staying healthy, abiding by the laws. Make sure that you think, is there's anything I'm going to say or do? Is the judge listening? Think of it that way. What am I showing up as? If the judge were standing there watching me, or the magistrate, what would that come across as? You have to be quite formal with your ex. There is no more relationship. You are not trying to co-parent. They're trying to counter-parent. You are just trying to have access so that you can parallel parent, although you will express your wishes that you would like to co-parent. But you know that's not going to happen really, okay? You can't wait around on this. I know that we saw them, we loved them. They're our children's mother, father. We spent a lifetime with them. We were in a relationship with them, but they darn sure are going to be making sure that they are getting legal advice themselves and they're planning their tactics, their attacks. They are most definitely going to be planning against you. They are not your friend. They are not your friend. And you, if you think, oh, they wouldn't do that, that's the stuff that they would do. You wouldn't do that, but they would. I'm just saying that because it's true. So you have to make sure that whatever you're saying to them, you're not going to give away all the secrets. If they're asking you, oh, what's going on here? Well, to be vague. It's fine. You don't have to give them all the information. Maybe that's what you were taught, conditioned to do. So when they start pressing you on things, you can learn to sort of maneuver around it. You don't have to give them all the details. You can even get a second phone number as well. So, yeah, get legal advice early, okay? Especially as soon as you hear or feel allegations, any allegation, anything whatsoever. They'll say, I didn't like how you did that to our son. They'll say, did you make that mark? They'll say, oh, our daughter came back and said you slapped her. Maybe the daughter wasn't there. Maybe the daughter was there, you know. Hmm. Know your rights. You've got to know your rights. That means you got to do your homework, okay? And also know the limits of what the court can enforce. And do know, what is it that you want to get out of this? Do you want to try and bash that person? Do you want to really destroy that person? Not a good idea. All you're trying to do is get access to your child. That is all you are trying to do. So, a couple of closing thoughts for you. Are you going to do this right now? Is everything okay for you to do this right now? It's going to take up mind space. You've got to get organized. Make sure, please, that you do not let it consume you, because it can. Treat it like a job. And I know this is personal, but if you get personal in it, it is going to eat you up. Have you already filed for a Form C100 or been hit with false allegations? What have you done about it? You know, I'd love to hear your stories on this one as well, so that we can help other people who are listening to this too. So why don't you drop your experiences or your questions as well in the comments? Let's create some kind of supportive space around this court process, C100s. And like I've said, I didn't go to court because I was told, well, she's going to be 12 by that time. And that's when I knew that there was no way that I could go to court. All I did was, in fact, I was told, take me to court. I knew, I knew. So now you understand the C100, you understand the C7, the C1A, and all those other lovely forms as well, the C79 and so on. All right. So can you please like, share, subscribe if this has helped you? Hopefully it has. Pass it on to somebody else that you think it might need some help as well. Also, some family court tips. If you know anything, jot that down too. It's a little bit out of my range of scope slightly, but this is a good place for you to be able to share. The other thing as well, if you need support, because this is very, very difficult to go through, the emotional support, the how do you survive this, then as a somatic trauma informed coach training to be for master's level, and I've been working with people for a long time on this, then you can book support sessions. Or if you just need a chat, first of all, then that's fine. If you do need coaching sessions, please do get a hold of me. Support at thepowerandcontrolwheel.co.uk. And you can check out the other social media. Join the Facebook page. Why not? That is at the Power and Control Wheel. Love to see you there. Share it all around, because these people do get away with things and we don't really know the law as well as maybe they might have looked into it before. It doesn't work in our favor. All we're trying to do is get access to parent our children. Not easy. It doesn't go the way that we thought. And my, oh my, does it surprise us? Okay. So God bless you. You'll look after yourselves. And don't forget, get in touch if you need that support. This is really hard to get through, but I can help you through that. Okay. All the very best. Look after yourself. Okay.